Being in an accident is tough enough, but depending on which state the accident takes place can determine how much money you can recover from another driver or another insurance company. In this video, I'm going to talk about negligence and the difference between comparative and contributory negligence. Before we get started, I want to invite you all to subscribe to the channel to stay informed and learn more about your insurance policies. So to start, what is negligence? Negligence basically means your actions caused harm or a loss to another individual. For example, if you rear-end another driver, you are 100% negligent for that accident. And your negligence would be that you were not paying enough attention to the road and keeping enough distance between you and the driver that was in front of you. Now there are two types of negligence: comparative negligence and contributory negligence. Comparative negligence looks at the drivers involved in an accident and asks the question, did one driver's actions cause the accident more than the other drivers? For example, if two vehicles are backing out of a parking space and they back into each other, and the damage is to the back bumpers of each of the vehicles, under the law of comparative negligence, both drivers would share the responsibility and recover 50% of the damages from their other driver. This is an example of pure comparative negligence, and each driver can recover money from the other party in the amount in which they are not at fault. So with this same example, let's say that driver 1's damages came to be $800 and driver 2's damages came to be $600. Since both drivers are 50% liable for the accident, driver 1 can recover $400 for their damages, and driver 2 can recover $300 for their damages. Now, comparative negligence laws also have what they like to call modifiers, and the modifiers can vary depending on the state that you live in. The modifiers will restrict how much money you can recover from another driver or the insurance company depending on your percentage of fault for the accident. Each state that adheres to the modified comparative negligence laws follow either the 50% bar rule or the 51% bar rule. 12 states follow the 50% bar rule, meaning a damaged party cannot recover if it is 50% more at fault. But if it is 49% or less at fault, it can recover for its damages. 21 states follow the 51% bar rule, under which a damaged party cannot recover if it is 51% or more at fault. Now, under the 50% bar rule, if a driver is 49% or less at fault, they can recover their damages. But how much they can recover is reduced by how much they are at fault for the accident. The same thing goes for the 51% bar rule. If a driver is found to be 50% or less at fault for an accident, they can also recover, but the amount that they can recover from the other driver is also reduced by the amount that they are at fault for the accident. So for example, if driver 1 and driver 2 were involved in another accident, and driver 1 is 70% at fault for the damages, and driver 2 is 30% at fault. Let's say if driver 1's damages came out to be $1,000, and driver 2's damages came out to be $300. Let's also say that this accident took place in Colorado, one of the states that follows the 50% bar rule. Given that driver 1 is 70% at fault for the accident, they will not be able to recover any of their damages from driver 2. But since driver 2 is only 30% at fault for the accident, they can recover 70% of their damages from driver 1. Now let's take this same accident underneath the 50% bar rule and say that both drivers were 50% at fault for the accident. Underneath the 50% bar rule, neither driver will be able to recover from one another. But under the 51% bar rule, both drivers will be able to recover 50% of their damages. Most states follow comparative negligence laws, but they differ between pure and modified comparative negligence. The chart in the video will show which states follow which particular laws. This chart here is a good reference guide to which states follow either pure or modified Comparative Negligence Laws. Now let's go to Contributory Negligence. Contributory negligence looks at drivers that are involved in an accident and asks the question, did each driver contribute to the accident taking place? If a driver contributed to the accident taking place, then they cannot recover any money from the other party. So for example, if two vehicles are backing out of a parking space and they back into one another, under the law of contributory negligence, both drivers share the responsibility and cannot recover their damages from the other driver. In this example, both drivers would be at least 1% at fault, and under contributory negligence laws, neither driver can recover from the other party. Only the District of Columbia and 4 other states practice impure contributory negligence laws, and they are Alabama, Maryland, Virginia, and North Carolina. So this has been the basics of negligence and the difference between comparative negligence and contributory negligence. If you found the video informative, share it with a friend. Subscribe to the channel, and thank you for allowing the Insurance Quotient to keep you informed.